financial advisor walk into a bar.
And then what happens, Dave?
Well, the question comes up, can I stop my ex-employees from poaching my customers?
Oh, good question. They're called restraints of trade, and everyone seems to think they're not enforceable, and that ain't true. They are enforceable. There's just some rules around it, So that'll be a great topic to chat about.
Yeah, because I reckon that's a really interesting one because, if we look at over the last couple of years, people have been working from home and doing bits and pieces, and we're hearing more and more of these stories from overseas that, people are resigning. And do we think that people will resign? And if they do resign, will they then say, well, it can't be that hard. I'll just take those customers over to what I was doing previously and just flip them to something else.
Yeah.
So, I suppose from a legal question, what is the real issue with that?
Yeah, so I think that's probably right. We've seen certainly a lot come in recently, and I'm not sure if it's related to working from home, but it does sort of make sense that if you're working from home and you're used to it, and then your employer says to you, well, you've got to come back into the office, and maybe you don't want to, and you think, well, hang on, I've been just basically running your business for you from home. I might just nab all the customers, start my own business. And there's the other side of it as well. I think that if people do resign, they might then go to another business. If they don't start their own, they might go work somewhere else. And then employers need to be, if they're hiring them, they need to be sure what, if there's a restraint in place, whether that's enforceable or what that means for them. It's no good hiring someone who you think is going to bring 10 new customers to your business, and then it turns out that's all illegal and you get sued by your competitor and it's all very bad.
Because clearly that would have been as part of their, if you're interviewing someone and the discussion comes around, oh, no, I've got access to all these good customers. Great. Well, let's, maybe we should bring them across. How does it kind of work? And that's, but can a employer ask that question of an employee if they have a restraint of trade or if their existing employment contract limits them in accessing those customers?
They sure can, yeah. It's a totally lawful question to ask. If you're worried about hiring someone, then you can ask that. If that's part of the kind of job description to go and get new customers, or to, if you're customer-facing type job, if you're a relationship manager or whatever it is, business development manager, then you can certainly be asked that, and it's reasonable for the employer to want to look at your old employment contract. And it's something that people don't really deal with in any kind of thorough way. If you've got a good recruiter, or they might. If you've got a good HR manager, they might. But often it's just overlooked. You hire someone thinking they're great, and then they get in trouble. They can't even approach their old clients for 12 months or whatever it is.
But is that the length of time that it normally is? If someone's got a restraint of trade, is it 3, 6, or 12 months, or does it depend upon the person's seniority as to where they sat with inside the organisation?
Yeah. Good question. So you've got to break it down. The first question is, are we talking about restraint of trade, which is about competition, or like competing, going and stealing customers or poaching customers, whatever you want to call it? So that's one type of thing. And then another's about confidential information, which is a different thing. Right. So the customer, if you grab the customer list and hold it in your hand, that customer list is confidential information, which is protected in one way. And then if then you start poaching all the customers, ringing them all, using, competing with the business, that's protected in a different way. And the reason I know it's sort of a technical distinction, but the reason I just say that is if you're using confidential information in any way, that's protected forever. So if you work for me and you nab my customer list and nick off, I can sue you and get the customer list back anytime, because the customer list is mine, not yours. And it doesn't matter 6 months, 12 months, 100 years, or maybe not 100 years, but it's certainly, any confidential information is protected sort of forever, and it's even protected regardless of what your employment agreement says.
But does that though? So, because the topic that we're talking about today is, can I stop my ex-employees from poaching my customers? So you're saying in that basis, if you, so there's two aspects of this. One, if you have an employment agreement in place that specifies that there is confidential information on customer lists, that there's a restraint that occurs through that, because it's privileged information. But then what happens if you don't have an employment contract with that individual who just happens to have sort of evolved or moved into, either they might have printed off a list, or they might have emailed it to themselves, or done something where they've got access to it? Does it require an employment agreement for you to be able to, I suppose, sue that individual who's taken the employment list or a client list?
Well, there's the contract itself, the employment agreement often provides certain things.
Yep.
But even if you don't have an employment agreement, then there's general law that covers both confidential information and competing.
Yep.
The general position is that confidential information is protected regardless of whatever your employment agreement says. You can't steal the customer list, even if you have no employment agreement at all, right? It's not yours. That's the position. But then with restraints, with competing, generally you can compete with whoever you like. So in the case of if there was no employment agreement at all, you couldn't steal confidential information, can't take that, but you can compete with anyone. You could poach customers, you could do whatever you like. So as long as you didn't use confidential information to do it. Do you know what I mean? So you didn't grab their phone number, you know what I mean, or whatever. Or grab their email.
But if you've got that that customer contact details either through, I don't know. You've got the, I mean, it really in the edge. You turn around and go, well, I've got their mobile number in my phone because they ring me because I was their primary contact. So therefore,
100%,
is that classified as stealing the customer contact details? As well, no, that was part of your duty of from the employment perspective, because that also then rolls into industry associations. LinkedIn,
and people you know personally,
all those, So to me, that's a really grey area when you start to look at that stuff.
That's true. I mean, I've had litigation over people's mobile phones and about numbers in their mobile phone. So it does get grey if you're talking about, and people that they know personally or that perhaps they knew before they got the job and all of that stuff. It can get very murky because, it might be a personal mobile that's got all this confidential information on it. And then what is confidential, right? Sometimes maybe you're working in a small industry. We're working for a company that sells trucks. There's only that type of truck might only be sold by 2 or 3 types of companies in Australia, right? That's it. So there might only be 2 or 3 possible customers, or whatever it is, or there might only be 10 and everyone might know who they are and their phone number might be on the internet, right? So it's not confidential. It's publicly available. Really, where it gets clearly wrong is where somebody goes to the customer list in the database, and presses print and prints out 150 names, contacts, phone numbers, and then rings them all. And we've had litigation about that too, where you go, well, hang on, you've rung the first 75 people on this list of 120, and all of this, here's a phone record that shows you've rung them one after the other. You know what I mean? So pretty clearly you have done it from the list. It's not like you went and Googled them. You know what I mean? It all does become very grey.
But should then, so from an employer's perspective, if you've got a key salesperson to perhaps help mitigate this going forward, should you as the employer then provide the person with a company-owned phone?
Yeah, so it certainly, it does get, it's clearer if you've got a company phone and a personal phone, and at the end of your deal with the company, if you leave the company, then the company come and say, I'll have that phone back, thanks.
Yep.
I mean, they may well delete what's on it, who knows? But it does make it clearer rather than that you're letting people use their personal phones. I think certainly in my experience, if you're going to pay for someone's personal phone, you may as well give them
a company phone,
right? Because you're paying for it anyway, and you may as well then and if somebody finishes up, you can say, okay, I'll have the company computer, I'll have the company phone, the keys, the swipe pass, whatever it is, all in sort of one go. And if you've sent anything to yourself, to your personal email or whatever,
which comes back to your audit trail that you can see through your internal IT systems.
So, I mean, they're all interesting questions and they do get a bit grey. But the general position, I think it's important to say, well, hang on, confidential information is one thing and competing is a different thing. And confidential information, the law protects that quite strongly. So you've got to be really careful. If you're an employee and you've got company information, you might think, oh, look, that's a customer I know really well. But, even like, say, your emails, right, your company email, they all belong to your company, not to you. And you might think they're your personal emails, but they're not. They're company emails. And if your company can, generally speaking, can read them and can certainly access them and stuff and can gather evidence against you, on them, because they're, while you're sitting at work, sending emails on your company email, that's all company information. It's not your personal information.
So what do the courts say about this? I mean, have there been cases that they are supportive? Because, I mean, I suppose the comments that I've heard from people is that it's very hard to kind of police this and enforce an employee who then leaves. It's sort of like, well, at what point where's that crossover point between the performance of your duties versus, well, I got to know these people on a personal basis, and therefore I'm happy to ring them separately outside to say that I've left ABC Proprietary Limited and now I'm working with XYZ. That's competition versus confidential then, really, isn't it?
Yeah, yeah. So we're talking about can you stop employees from poaching customers? And I think there's certainly a grey line between what you sort of do personally and what is company activity, and it can all get very murky. And it also can be like if say your best salesperson leaves and a bunch of customers follow them, if you then sue that salesperson, sue their new employer, and sue all of the customers potentially, that's not a great look, right?
Correct.
And so maybe
that's one way to stuff your business, isn't it?
Yeah, and maybe if you did sue them, maybe you wouldn't be able to get any evidence against them anyway, because it's all they've written down the phone numbers on a bit of paper that you could never get access to or whatever. So I'm not recommending going around suing everybody, but I think you do need some basic protections in place, like you need to make sure in your employment agreements you have a restraint. And you have confidential information clause, so it says what confidential information is and isn't.
Yep.
And just clear about that. So and then at the end of your employment, when somebody leaves, you say, okay, well, all the confidential information has to come back to us, and you have a process to do that in a way that's sensible and fair and not bloody minded, or you don't have to walk everybody and and audit everyone's computer. But there needs to be a process around that just to minimise the risk.
But that's hard, isn't it? Because if you've had a person I suppose it would be different. If you had a person that may have been working with you for 3 or 6 months and they're potentially in their probation period, or they're just outside their probation period, versus someone else who's been working with you for, say, 5 or 7 years, that becomes really difficult. I think that sure, they might have then approached some of your customers, and how do you really stop it? But if they've got that personal relationship, in the end, the customer is the customer, and they're buying
they
from.
Know where they like.
It's like, well, the reason I was working with ABC was because of Alex. Now Alex has moved to XYZ. I like his style, therefore I'm going to move my business over.
Yeah.
Which also could then deal with your risk management that says, well, there shouldn't be a single point of contact with some of the key customers.
Yeah, that's right. I think if you take it back another level, that's absolutely right. I mean, the reality is people do follow people. People do business with people, not with brands and businesses and stuff. And particularly in professional services, if you like, me, then and I move firms, you may well follow me. And to some extent, there's nothing you can do about that, right?
Yes.
To some extent, that's just part of life. But I think having multiple contacts with that person, or that person, the sales manager might talk to them every day, but maybe the CEO or whoever else, the operations manager, talks to them once a month, or makes key decisions with them, or is involved in some way. Because ultimately customers can go wherever they like, and you can't really stop them. And so, you want to have a good relationship with have a deeper relationship with the organisation, if you like.
So is that where, from a legal perspective, you would say that have your agreements in place with employees just to at least make them aware of the fact that it's very clearly articulated for them that there is an expectation that they don't take customers with them. However, very hard to police, can cause all sorts of reputational damage for you as an organisation if you're chasing, because there's also that balance that to me, you then can't allow an employee to leave, and therefore the customers may go with them, because there's also a limitation that says, well, this individual that's left still needs to be able to make a living, and therefore it's difficult to say, well, I don't want you touching those customers. It's like, well, you don't really. I've got to make a living. I've just moved on.
Yeah. Yeah, and the court recognised that. So we talk about putting aside confidential information. If you just talk about restraints, so that's a provision. If we're talking about, can I stop my employee from poaching my customers? And the way you do that is through a provision in the employment contract which says, you cannot poach these customers, you cannot do whatever, poach these customers or poach these other employees or whatever, maybe even compete generally. Some of them they say you can't compete at all in your employment contract. So that's all doable. That can go into the employment contract, but whether or not it's enforceable really depends on how the extent of the restraint. So if it's very onerous, especially on a very low-level employee. It's unlikely to be enforceable. And if it's a more senior employee and it's more narrow, the narrower the better. So I think that the advice really to small business owners when they're thinking about, can I stop my employee from poaching my customers, is you can, as long as you've got a well-drafted clause in your employment contract, which is as narrow as it can reasonably be. So you might say, look, you're a plumber, you can go out and do all the plumbing you like for anyone you like, except these 3 customers, which are our main ones, and you're not allowed to approach them for, say, 3 months or 6 months or 12 months maybe even, but or these 10 customers or 20 customers or whatever. Make it as narrow as possible, especially for your key people. And if you're talking about your receptionist or your front desk person or someone who answers the phones or whatever, or a junior admin clerk or whatever, you don't restrain them at all. I mean, because normally if those sort of restraints are going to be unenforceable, if they want to go next door and work for the competitor answering the phones, there's probably very little damage they can do to a business.
But do the courts? So when you talk about 3, 6, or 12 months of limitations of people approaching, do the courts look at that and say, well, 3 months is probably reasonable, 6 months, is on the borderline, but 12 months without accessing some of these customers is unreasonable? Do they start to look at it from that point of view?
They do. So the courts will say, and if you just have let's say you have a 12-month restraint from competing generally, just from competing they might look at it and go, well, look, the competition restraint is okay, but 12 months too long. And if you only if the clause just is a 12-month restraint, then the clause they'll put a line through it, they'll strike it out, and then there's no restraint at all. The employee can compete all they like. So the important thing in drafting these clauses is they cascade, and you might have seen them. Sometimes you see them in employment agreements where they say you're restrained to do this for a month, if not a month, then or for 12 months, if not 12 months, 6 months, if not 6 months, 3 months, and that way they're still, you can strike out the relevant bit, but they're still enforceable if the court thinks it's too long. But 3 months has been enforced in lots of different cases, so 3 months people generally use as a reasonable period, but it really depends on the extent of the restraint, right? If it's restraint across Australia for competing generally for 3 months, that's probably still too full on. Whereas if it's a restraint from approaching 5 key clients, even if it's for 12 months, maybe that's okay. You know what I mean? So
because that was the other question. Is it a geographic split that you can put in there? Or generally, if you make, again, it's too broad. So I suppose is the advice then to keep it as narrow and as specific as possible.
Exactly.
At least to put some hurdles in front of it.
Yeah, and often if you because people don't normally turn their mind to it, they just bung it in their employment agreement and make everyone sign the same one.
Yep.
Which, I can see that makes sense from a cost point of view, from a simplicity point of view. But if you've got key people, I think you can have one for everyone and then one for your key people. So if you've got, head of sales, or you've got someone who's got access to all your customer information, or key partners in the business, professional services, each partner might have a senior type employment restraint, and that might name their key customers.
Right.
If that's much more specific, and often if you actually turn your mind to it, think about it, there's a much more reasonable restraint that's available that everyone could agree on. You might say, well, look, if we're in partnership together in an accounting firm, you say, well, if you bring in customers, you can take them with you, because they're your customers. But if I've given you a customer, then they have to leave them when you go, and you might accept that, and you might respect it and avoid a dispute with me, when you leave, as long as the restraint was kind of drafted in a way that everybody understood and that was kind of reasonably proportionate to what you're trying to achieve,
And that's where you really hear the comment that people say they're on 3 months gardening leave.
Yeah, exactly. Yeah, so they go and do nothing for 3 months, and then they ring up all their clients, or, it's not uncommon to have maybe you've got a 12-month restraint, and you go and approach all the customers that aren't mentioned in your restraint, and then after 12 months, then you ring the ones that you are, and you ring them, and you can say to them, look, I had a restraint in place, and I respected that. As I respect my old employer, and now the restraint's finished, and so now I'll give you the opportunity to come across and do business with my new team if you want to, and everyone's happy. Your old employer goes, okay, fair enough, that was agreed. Your new employer's happy with that, and your customers there is a way of kind of navigating it that's respectful, and that you can hold your head up high without sort of being sneaky about it.
So is there a distinction that, if you look at it, because we've got so much like electronic records are in place? As an individual, they've left their employer, they've gone over to the competitor, and they're looking to bring across those customers from the previous employer. Would it be different, and could it be held to be the place that if I look at it from if I'm doing an outbound conversation from my phone to the customer
Yeah.
versus the
Yeah.
customer ringing as an
Yes.
inbound call,
Yes.
is that a distinction? Because all of a
Yeah.
sudden you can put it out differently. If it's like, I didn't ring the customer
They rang
rang
me.
me.
Yeah.
And,
Yeah.
that
No,
I
yeah.
haven't, there was no restraint of trade that says that I
Yeah.
can't do that. I didn't
Yeah.
proactively pursue them. I've
Yeah.
adhered to my, what was in the original employment agreement, but the
Yeah.
customer followed me.
Right.
Do the
Yeah.
courts look
Yeah.
at that and say, well, that's reasonable?
They sure do, yeah. So when you're dealing, I mean, I hope nobody ever has to deal with litigation like this because it can be pretty nasty and pretty expensive because it's quite complicated. But if you're dealing with litigation about stopping your employees from poaching customers, then it can get down to that granular level of, first of all, what does the restraint actually say?
Yep.
And the restraint sometimes says you won't approach. They often use the word solicit. Solicit means to actively ring someone up or say, it's what solicitors do all day, and I think other people do soliciting as well. But it means to actively, to try to pursue someone. So if someone calls you, that's not solicitation. So it depends on the wording, whereas some restraints will actually say that you can't accept an approach. And that's, again, more difficult, more broad, so more difficult to enforce. But if that was enforceable, then even accepting a call might be
Oh, so
wrong.
you can actually be that specific in some of those documentation. So it comes back to the wording as to if you're not able to accept an inbound, but
Right.
okay, that's interesting.
Yeah, so that's pretty severe.
Yeah.
And normally that would be in a case, say, let's say we're partners in an accounting firm, and you buy me out. You pay for the goodwill of the business, and I go off and I'm going to retire, but then I nab a bunch of your customers, right? In that case, even if the customers rang me, because you've bought the goodwill of the practice, in that context, stopping me from even accepting an approach might be legal, might be enforceable, right? Because, so it all depends on the context, what's going on, who's, and where you buy a business, the restraints can be much more severe. They can go for 5 years, 10 years.
Yeah. But that's different though, as opposed to
exactly.
That's more of a purchase and sale situation, as opposed to an employee that was being paid to do a particular job and then transfers across.
Right. Yeah. That's right.
Yeah.
But when you're talking about, can I stop my ex-employee from poaching my customer? I think there's the employee side of it, which often we talk about whether the restraint's enforceable and all that. But there's a real employer side of it that, if you're hiring someone, you want to be clear about what they can and can't do and for how long and so on. And there's often a way through it. Like you hire someone and as I said before, you can say, okay, well, for 3 months, you're not allowed to compete at all. So maybe you put them on gardening leave for 3 months, even though you've hired them, or maybe you get them doing something in the office. They get organised, learn the systems or whatever, and then they can approach. They might be able to approach customers that maybe new customers that weren't involved in their wherever they used to work. So they can do something for a while, and then they can do something else, and then as their duties can sort of expand, which often happens naturally anyway. So you can hire someone with restraint. You can respect the restraint, and you can still make use of that employee in the long run.
Because it's also that issue that if they're functioning within the same industry, your employer that you're leaving and moving to another employer in that industry, then there's always the issue that the existing two owners or directors of each of the businesses would all generally know each other. Not always, but a lot of the time people may have crossed paths with each other and know of themselves, and therefore they've dragged someone over, but now they're starting to pinch their customer base. That's always an interesting one, isn't it?
Yeah. Well, that's right. Yeah. I mean, and often these things are resolved, just by negotiation, by people talking to each other, and they don't go off into court. And if they do go to court, they're pretty nasty. So it's something you want to really avoid if you can. Often you get an exchange of letters where you get a letter from the ex-employer saying, hey, you're not allowed. You've got confidential information. You got to give back the customer list and all that sort of stuff. And it often doesn't go anywhere. But when it does, it's pretty nasty. So it's something that's not well understood. I think people often say to me, "Oh, I've got this employment restraint, but it's not enforceable, right? Employment restraints aren't enforceable."
Yep.
I said, "Well, they are. They are if they're kind of reasonable and proportional. They're just not. You can't restrain someone from earning a living. That's the kind of principle."
Yes, and that's the real issue that you hear about, isn't it?
That's the real issue, yeah. And that makes sense when you think about it. You know, if you've got especially if you've got a particular skill in a particular industry, and maybe it's narrow, maybe you're good at, checking Ford engines for performance, and that's it. That's all you do. You're a highly qualified engineer or mechanic or whatever. Then there ain't that many jobs around doing that.
Yep.
So there's only a certain amount of people that you can work for, and the courts certainly won't make you go and work outside of your skill, go and become a gardener or something.
Yeah.
They'll respect that you've got to work for your skill. But it's really when you do it in a sort of an unfair way or get an unfair advantage from your ex-employer, that you bring to your new employer. That's it's the unfairness that the court are worried about.
Yeah.
And a restraint that's as narrow as possible is fair. So that'll be generally be enforced by the court.
So then what are your sort of key lessons as we kind of wrap this one up? If you're concerned about, potentially that you've got some very valuable customers and you really want to make sure you hang on to them and that, you're bringing on people into your organisation, what are the key things that people should think about?
Yeah, so I think the key lesson when you're talking about can I stop my ex-employee from poaching my customers, the key thing is you want to have a restraint in your employment agreement in relation to competition and make it as narrow as possible for the particular circumstances. So it needs to be crafted for that person or for that level of person. So that's the first thing. Then the other is should be thinking about confidential information separately to restraint. So there should be a confidential information clause, and you should be careful about what information they can get and where it's stored and all that sort of stuff, personal mobiles and all that sort of stuff. And then finally, I think you should have a process around if people do leave, around getting the confidential information out of them and making sure they know kind of what they can and can't do, and not just what they can't do, but what they can do. So, well, you can approach all of these truck manufacturers. They're not competitors. You can sell stuff to the council, but not stuff to the local government or the state government or whatever it is, wherever your market is. They go and work for a competitor. As long as they don't directly harm your business, then they should be allowed to. So would you also
then encourage people to do an electronic audit to make sure that people haven't been sending customer lists out to their own certain number?
You sort of hope that you're at a position where you don't have to do that as routine. There's certainly, you can send off any computer to a forensic examiner and they can find out all sorts of stuff. But it sort of depends on the sophistication, I guess, of the business and where they're at. If it's a big enough business to justify that kind of routinely, then that's not a bad thing. But people often put a memory stick into their computer, and we've had litigation about this, put a memory stick into their computer and take off stuff. They're not stealing files. They're getting their personal photos, or they're getting their own emails, their emails with their utilities provider or whatever.
Yeah, because it's all blended in, isn't it?
It's all blended, yeah. And I think especially when we're all working from home, everything's blended like nobody's business.
Yeah, that's the worry, isn't it?
Yeah, that's right. I mean, in the end, I suppose, like anything, it's down to relationships with people and, being kind of fair. And the courts will, if you give people proper notice about what they can and can't do, they'll generally sort of respect that. It's when there's confusion. People really, they do think that the information that's from work belongs to them, and that's just not right.
Yeah, and I think that's the real sort of fine line in there, isn't it?
Yeah, that's right.
All right, well, there we go, people. There's a magnificent piece of legal advice that's just in general circumstances have been provided. Comes back to, doesn't it? One, making sure you review your agreements, but communication. And I think in the end, like anything, communicate with your people and let's hope it doesn't go down that particular path of get into the courts. Yeah,
you've got to think ahead with these sort of things because your relationships with your customers, that's the value in your business. So you've got to protect that. Think ahead, talk to your people about it and put contracts in place that reflect that. That's right.
All right. Beautiful. Alex, once again, quality as always.
Thanks, Dave. That was great. Nice to talk to you, and we'll catch up again soon.
Fantastic. Thanks for that. See ya.
Thanks. Bye.